take any of the questions and
Yes, while coming here, I actually look at this particular question from 2023-24 first semester law exam. Because of time constraint, I've just looked at two questions, and the two questions, as each of them has A and B part. The A part, an essay. The B part, a problem question. Okay? Yes, I said there are two questions I would like to run through if time permits. And each of the questions has two parts. The essay part and the problem area part. Now, let me first take, I think this is question 4A of the last exam, and it reads, prepare a brief on the customary land tenure system as practiced in your locality. Prepare a brief on the customary land tenure system as practiced in your locality. This should briefly cover the creation, ownership, management, and determination of family or communal land in your locality. You see, this is one of the simplest questions you can ever get. The question could have stopped at the first sentence. Prepare a brief on the customary land tenure system as practiced in your locality. And you still have to write all these things now being asked, all the concept now being asked. But in order to assist the student, and in order to streamline what they are supposed to focus on in answering that question, the question went further to say, this brief should cover creation, ownership, management, and determination of communal land, family or communal land in your locality. So you have four major areas to concentrate on. If there are more, yes, if you have other issues, yes, that would be an added point. But you have four major areas to concentrate on. And the question has given you a discretion of the customary system you want to pick. If the question has said that, okay, in Yoruba land, an Igbo candidate may be wary as to what to write. If the question has come at in Fulani, then other tribes may have issues. But it has given you liberty to pick the one in your own locality that you think you know. Nobody knows your locality is who. Whichever one you pick is what you are going to examine you on, particularly with respect to creation, ownership, management, and determination. Now, having said that, the first point of reasoning in this question is, what is customary land tenure system? And what are its features? You see, the examiner knows that the customary land tenure system exhibits similar features, general similar features in all communities. Yes, there may be some little variations, but a general similar features operates in almost all customary land tenure systems. So you have to identify that. Then you now dovetail into your own particular the one you have picked as your own customary system. And you even have liberty also whether to pick family or communal. So it is free. But in doing that, you just need to touch minimally on all these four issues. How is it created? Who owns it? What is the management structure? And how can it be brought to an end? So once you address those issues, nothing less than 6-7 marks over 8.
Prof, let me ask a question with regard to that question. And then my question is this. They were asked to pick in their own community. Let us assume that in class they were only taught the Yoruba customary law system. I don't know that of your community. Would it be advisable for a student to just write on that which was taught in class. Because that is what he knows.
Well,
this examiner may not know your tribe anyway.
You see, that's the cover.
That's the cover.
You only put your matric number, not your name.
Exactly.
So even if your name will have revealed your area of your community.
Yes.
The fact that it is only matric number, nobody see it is faceless response.
Exactly.
So just pick any one of your choice.
Because may think I don't know my tribe, so I won't answer the question.
No.
That's not it. So you have to have some
it is just to give you
like psychology of exams.
Exactly. Just to give
you a framework to
answer the question.
Thank you so much. Thank you so much.
Now I will take the B part. The B part is a problem question. The B part reads, Alhaji Agbaje is the head of Agbaje Lola land owning family, of which Segun and Bode are members. So we have 3 members in this family. To pay off some pressing debts, Alhaji Agbaje sold a portion of the family land to Chief Dapo. Segun, also in their need of venture capital, mortgaged his interest in the family land to Okeke, while Bode pledged his share to Disu so that he might raise funds for his child university education. All these transactions were carried out independently of each other and without the knowledge and connivance of other members of the family. See, if you have answered the A part of the question very well, then there's no problem for you to answer the B part. And what are the issues here? Oh, the question is, what interest, if any, have Chief Dapo, Okeke, and Disu acquired, respectively? You see, this is a problem question, but the issues are already identified for you. So you have to talk about the interest acquired by Chief Dapo, Okeke, and Disu. So that tells you 3 major issues. Now, to be specific about the issues now, to identify the issues, the question has already identified the issues by telling you that, okay, what is the interest? Yeah. Now, you now have to pick each and every one of them. Chief Dapo. What happened to Chief Dapo? Chief Dapo bought the land from the family head, who sold the land because of pressing debt. Now, the family head, what right does he have with respect to family property, disposition of family property? You should be able to recall that there are void sale and there are voidable sale that could be carried out by the family head. So you have to identify the 2 here. Though the question is open-ended, but to tell the examiner that you really know what you are talking about, you have to identify the 2 variants of the rights and powers of the family head with respect to the disposition of family property. In what capacity did he sell? We are not told. So that further tells you that you have to bring out everything, yes, of the family head powers to dispose family property. Yes, pressing. We are just told here to pay off some pressing debt. Is it family debt or personal debt? So we don't know. So therefore, you have to talk about it in those 2 circumstances. Yes, where he disposed of the family property as his own, then the transaction is void. Where he disposed of the family property to Chief Dapo in his capacity as the family head for the purpose of furthering family interest, then the transaction is voidable because we have been told that neither member it was done without the knowledge of other members of the family, so it is voidable. And you just put your case law to support it. Even where you fail to put a case law, It is the case law that tells us that, oh, this is a lawyer in the making. But even where you fail to put the case law, the applicable case authority, you still pass. Yes, I can tell you, if I'm the one marking that paper, you still pass because the principle that is applicable, you know it. But where it has been applied, you have failed to. Anybody that now puts a case law will now definitely get a higher mark than you get. But the principle that is to be applied, you have actually been able to identify. Now, that is with respect to Chief Dapo, who bought the land from the family head.
Would it also be necessary to now go further and tell and express an opinion that if the family member, other members, the principal members, assent to the transaction, then the voidable transaction?
Yes, exactly. That
takes you to a higher level.
Yes, that is actually where you have to end it. If the transaction is a voidable transaction,
yes,
that okay, non-consenting member can object to it.
Yes.
But if they don't,
yes,
it's perfected more or less. Yes. So silent will be taken as consent. Now, with respect to Shegun also, in their need of venture capital, mortgage is Shegun is a principal member. It's not the family head. So he also mortgages interest in the family land to KK. What right has a principal member to dispose of a family property without the consent or concurrence of the family head? The law is that it is void. Yes, he did not dispose, he mortgaged, yes. What is the status of mortgage in this case? The law is still the same. That where he sells, dispose, charges, pledges.
Alienation of any.
Yeah, alienation of any kind. Then, if it's just a principal member, then the transaction is void. So the transaction between Shegun and Okeke will get no title because the transaction is void. Just put your authority there. You see, another good point we can emphasize here is that you can just put the case without even discussing it. The authority for saying this is the case of Okoko and Wanko. We already know.
So it's not in all cases you have to be discussing.
No, it's not enough. It is only the question requires you to discuss the facts of the case. The authority for this conclusion is as decided in A versus B, and that is, you don't need citation. What is it? 1925 AC. No. Just put the case there, and then you are done.
Do they have to use the red biro to write their case?
Ordinarily there is no law that says you can't use all true, but you see, an examiner who is marking 300 scripts, they easily get bored. I'm just opening the mind of the examiner to you people now. You may easily get bored by just reading through. But at times, if there's a striking color to write the case, a red ink, or a contrasting color to the one that you have been using, the eye of the examiner may go there straight and see whether it is the relevant case you have actually mentioned there. So if it is a relevant case, then it will become more presumptuous about your position in what you are writing. So it can indirectly aid the examiner and you in the process of examining your paper. So there's no law that says you must use red, but it is advisable that you use contrasting color. Let me just put it that way. Contrasting color to write your cases so that it will be eye-catching for the examiner to be able to see and say, oh, is probably in a one-page write-up. The case is around in the middle, on the middle page, middle line rather, and the examiner is reading from up. At times when you are even writing, you may veer here without, but immediately he sees that case and say, okay, oh, this is the authority. Yeah, he got the authority.
Yes.
Okay. Now let me be more attentive to what
This
he's saying.
Thank you so much, Prof.
So I was looking at
Third part.
the third person, the third sale, which is who now? Bode now pledged his own part of the family land to somebody else in order to raise capital for his child education. That is also a way of alienating or putting an encumbrance on family property, and being a principal member, he has no such right, so that transaction is also void. I've taken this long to answer this question, but in an exam, this question, the two questions can be answered in 20 minutes. For example, this problem question, once you see the first one, that is the family head and the other person is sold to, you just see family head, void transaction authority, voidable transaction authority. Principal members, mortgage, void transaction authority. Okay, pledge, void transaction authority. Once you have that, you have already written answered the question informally.
Yes.
By the time you put pen to start now writing, you will see that in less than a few minutes you will have answered the question. Nobody likes stories. No, it is not the stories that.
Yes.
It is not how much you talk when you get to court that gets the judge to give you what you want. It is the substance of what you are putting through, and it is the substance that we are now trying to examine when we have your question papers before us.
So that helps students who have also asked us how many pages we should write in exams. We are not counting pages.
No, there's no problem about pages.
We've asked first class students who write very few words. Is the weight of your words, the substance of your words that of your scripts that matters, and not the number of pages or you are writing, because precision is always better than.
Sure, exactly.
Yes. Thank you, Prof.
If I may still go through the second question.
Yes.
Which also has two parts, the essay part and the problem question part. That's question 5. 5A reads, the enactment of the Land Use Act signaled the death knell of the customary tenure as known to the indigenous land tenure system in Nigeria. Well, this seems to be a long grammar. But if you just turn it round, what is the impact of the Land Use Act on customary land? Simple. And I know this is a particular topic that must have been taught in the class. When you are taught the Land Use Act, you have been told when you are taught the Land Use Act, you will have been told when you are taught customary land tenure, customary tenants, customary pledge, and what have you. You have been told some of the impacts of the Land Use Act on it. And so it's a very straight, simple question. So you just need to identify the customary land. Okay, it's even here, customary tenancy. You see, customary tenancy.
Okay.
So you just need to describe what a customary tenancy is, its features, to let the examiner know that you know what this customary tenancy is. Okay, what has the Land Use Act done to that? Then that means you have to go to some sections of the Land Use Act and some case law to see how the Land Use Act has impacted on the customary tenancy system. That was it. Simple.
That's it.
This B part of the question. This B part particularly is one of the questions. It's a representative of the new model that I said earlier that we have now fashioned to assist the students at identifying the issues. The question reads, Olu Anisimi, a member of Olaburete land-owning family of Ago-Are village, Ogun State, was allocated a vast portion of virgin communal land by the head of the Ago-Are community in 1970 for farming purposes. Recently, in 2023, Oluwanisimi obtained a certificate of occupancy from the Ogun State governor and laid out the land into plots to sell them in lots? Simple question. You see, that is the problem. But the question I ask you, the question could have stopped there and say and tell you address the issues. In that, most students will just be going, telling you stories. And ordinarily, this is a question that should have been answered in one and a half pages work. But they'll be telling you story, asking for extra sheet, and what have you. But in order to streamline and guide the students as to what we want from them, then the question now goes further to say, answer the following question. What is the nature of Oluwanisimi's interest in the land? So the question is, does Oluwanisimi become the owner of the land simply because the family had allotted to him the communal land for farming purposes since 1970? So that takes you back to your understanding of customary land tenure system. Analogy of land remains analogy of land, not the owner of land. Yes, the interest is inheritable, but it does not mean that he is the owner of the land. The authorities on that just put it there to answer that question. Now, do you think that Oluwanisimi's interest in the land is of such a nature that can support a claim for a right of occupancy under the Land Use Act? The question is now taken back to the Land Use Act and the relationship between the Land Use Act and customary land tenure system. And if you go back to the case of Yakubu, the landlord and the land user has not come to rob Peter to pay Paul, we will know what the answer is. Whether I can support, I cannot support. And there is even a provision.
Okay.
Yeah, on that particular question, that do you think that Oluwanisimi's interest in the land is of such a nature that can support a claim for right of occupancy or a right of occupancy under the land user? Yes. I said that question wants to test your understanding of the relationship between the Land Use Act and the customary land system. And you can even go further to, if you are good enough, to identify a particular provision of the Land Use Act, which says that if you apply for a C of O, which is a right of occupancy, but the interest you have is lesser than ownership, that C of O will reflect that's the interest you have. Yeah, and the case authority on that also. Now, the third question here is, in what circumstances will the subdivision of land into plots and their sale be unlawful under the Land Use Act? It's just to take the section
of the land.
Yeah, and put it there. If you just say section so, without even saying who the provision of that section, we know what that section says. We will give you a mark. So you can see that the questions are put in place on the understanding of what you have been taught in the class. So it should not be a problem, really. But like I said earlier, the major problem I have identified is that students rush to answer the question and end up cancelling. We've seen students
not answering the question.
Yeah, not answering the question, or even cancelling 3, 4, 5 pages of what they have written. They will never get that time back.
Yes.
And at the end of the day, they will have to be patched up to score 1.0. So that is just.
Prof, this is very, very interesting. And I'm sure that land law students, we are good to go with regards to answering questions in exams. We've had what Prof has said, that we need to read our questions very critically and create a structure for our answers before you start writing in prose, so that you have a clear direction of what you are doing. And he's also told us that there are different ways that problem questions are set. Some they already identified the issues for you, some you have to identify, and you have to determine which of those types you are dealing with. So at the end of the day, don't forget what he said at the beginning. He said the default setting, and the presumption is that you know it, you already have 10. So we should not approach any exam with fear. You already have, like, let's say it's 10 over 10 marks maximum. The default setting is that you have the 10, and then you need to see where one or two things are missing and remove. Not that the default setting is 0, which will make you think, oh, if I don't measure up, and you have to mark it up for me to get up to 10. So let's begin to shine as students of land law. Not only land law, because this video would also help every student of law in terms of approaching their various subjects in exams. And I hope that we are going to be seeing greater and better results as time goes on. Thank you, Professor Otubu, for coming on board.
My pleasure.
We hope we'll always be able to call on you to assist our students in this regard.
My pleasure,
okay.
my pleasure. And to the you students, you see, enter the exam hall with all the assurance that you are going to do well. When you go for exam, never approach it with fear. Go with the assurance that you are going to do well. It is only those who have never read or prepared for the exam that should fear the exam. Exam is not a life and death issue. They are just trying to bring out what you know from you. You are just to convince us that, oh, you know this. So there's nothing to fear about. I've never involved myself in exam malpractice. It doesn't worth it. Because once you are caught, you might have. With that, wave bye-bye to your law school and your law profession. So the word is enough for the wise. Thank you.
Wow, thank you so much, Prof. That's a fatherly advice. It has gone beyond the call of duty to give us a fatherly advice. No exam malpractice. Law students, land law students, begin to shine. It's time to shine. There's nothing to fear. Thank you once again for being part of this discussion, Professor Otubu. And see you guys at the next presentation where we'll be talking about exam tips. Don't forget to also subscribe and like this video.